Thank you very much, and thank you very much you all for being there in attendance of this webinar organized by Privacy Rules together with the For Mobile project and various project partners, some of which are represented here. My name is Andrea Milinski-Bigazzi. I am the coordinator of Privacy Rules. Our alliance is present in 56 countries in the world. We are present also in Belgium. Pieter Gryffroy represents our member from Belgium. And the initiative of organizing this webinar is because evidently the topic at stake is really relevant for what concerns privacy rights, but at the same time, the need to investigate the bad guys that are committing crimes with or over various platforms. Privacy Rules also deals and works on cybercrime, and this is the reason why we were very much interested in organizing this webinar, offering to all of you a fantastic panel of experts. We have 5 of them here today, representing, if you want, the various souls and the various kinds of expertise, the most important ones that you can find in any investigation or in any case whereby data have to be extracted from mobile phones and from the cloud. I will start from Denitsa. We have agreed that we introduce ourselves by first name. Denitsa is the head of the Human Rights Department of the Law and Internet Foundation in Bulgaria, and has been very important for the development of the For Mobile project, which is still ongoing. So you can find information about the For Mobile project online on the website of For Mobile, and also see which are the goals that the For Mobile project has ahead. We have Denitsa will be co-moderating this webinar together with Pieter. Pieter, as I mentioned, is from Belgium. He's a lawyer. He's a lawyer specialized on IT law and data protection, and is also Timelex, the law firm that Pieter works at, is one of the partners of the project. To remain in the partners of the project, there is also Mike Dickinson, representing MSAB, which is a digital forensics company based in Sweden, which evidently has an important role in supporting law enforcement, supporting investigation for what concerns the extraction of data and the use of data eventually in court for criminal proceedings. Talking of which, we have Martin from the Netherlands. Martin is the senior national public prosecutor for digital investigations, a new appointment that Martin had since March this year. It's very interesting that the Netherlands have not only specialization for what concerns cybercrime investigations, but also specifically for digital investigations. This gives a clear indication of the importance of the evolution of the investigative capabilities of judicial and prosecutorial systems within the European Union. And then we land with Krešimir being a lawyer in the registry of the European Court of Human Rights. Obviously, it's very important to have the view and opinion and overarching opinion, I would say, of a representative of the European Court of Human Rights, or better to say a lawyer that works in the registry, because of course, the disclaimer is that everyone is speaking in own capacity, but not representing official positions of respective institutions. It's particularly important to have Krešimir here because evidently the views and the interpretation of these matters by the European Court of Human Rights are to be followed and implemented in the judicial systems of Europe. I would close here. I don't want to take much of the time of the audience. I would immediately pass the word to Denitsa and Pieter. Just anticipating one answer that surely we will receive through the chat, which is always, are we going to receive the recording of this webinar? The answer is yes. So Privacy Rules will publish this recording in the next weeks. So those of you who might miss part of it will find the full recording on our platform soon. And I invite warmly those in the public to submit questions through the Q&A button at the bottom of the screen. I'm sure that the more questions you will have, the better will be for the debate among the panelists and the co-moderators. and those who might also replicate your questions via the Q&A again. Thank you very much. Welcome once more from Privacy Rules.
Great. Thank you, Andre. And first of all, thank you so much for the invite to host this webinar and to speak a little bit more about mobile forensics and what is their interrelation with cloud data extraction. So I'm happy to moderate alongside my colleague Peter the debate that is going to evolve and unfold during this webinar. But first of all, let me share my screen and just present you some key points on behalf of the project and also in terms of what we are going to talk about today. So I hope that you can all see my screen. So what is going to be the agenda for today, what we're going to speak about. So first of all, I'm going to give you a very brief introduction of our project for mobile. And then Peter and me are going to present, let's say, the highlights of the results of our research so far. Then our speakers, so whom you already presented, each will provide their intervention and they will provide their take on these issues that relate to electronic evidence accessed and used via mobile phones. And after all, we have prepared some short list of questions in order to spike a really animate live debate and discussion between the panelists. But of course, we are going to conclude with a Q&A session asking, let's say, the most interesting and insightful questions that the participants today will ask. So first of all, what is For Mobile and what we're doing there? For Mobile is a 3-year project supported by Horizon 2020 in the field of fighting crime and terrorism. And what we strive to do in the project is to create an end-to-end mobile forensic investigation chain. We are a lot of partners, 19 partners, representing 15 countries, and we have even one country from Asia, so this is Kyrgyzstan. And the main results of the projects follow 3 main streams. So the project is working on tools. The project is working also in delivering a standard when it comes to mobile forensics. And last but not least, we are working also towards not only the design of a curriculum, but also providing trainings within the project. And when it comes to the tools themselves, they're divided in 3 main steps, so acquisition, decoding, and analysis of data. When it comes to our work, so what the organizations that me and Peter represent, what we are doing in For Mobile is basically aiming at 2 directions. So the first mission, let's say, that me and Peter have in this project is to ensure that the project is implemented in line with the relevant legal but also ethical frameworks as the project as such. And on the second level, our work really focuses on not only supporting the development of the tools and their design, so they are really embed the relevant legal and ethics requirements. We're working also in supporting the work on the standard, propagating such guidelines, again, from legal and ethical nature. And last but not least, we're also contributing to the curriculum that is going to be presented later this year on. But in addition to all that, we did a quite, I would say, ambitious research, and we yielded very interesting results that took place over the course of last summer and autumn. We delivered a very comprehensive criminal procedure comparative report where we managed to do an analysis of 30 different jurisdictions across encompassing all EU member states, but also the project partner states, which are now the UK, Norway, and Kyrgyzstan. So we really took the time to analyze the mobile forensics implications in both stages of the criminal procedure, the pre-trial and trial stage of the criminal proceedings. And we did this analysis bearing in mind what kind of fundamental rights could be involved in these different investigation and later on prosecution and then when the case enters the court stage. All of these steps we really did analyze from the EU perspective, but also on national level. And my colleague Peter is actually going to speak a little bit more in terms of the national perspective. But if you allow me, I'm just going to use the end of my time just to provide you with a brief summary in terms of what are the main findings when it comes to the bird's eye view EU point of view when it comes to not only the extraction but also the sharing of electronic evidence. So don't mind me, I'm speaking very briefly. So what is the scenario and what was our departure point for the analysis? So please bear in mind that in Phone Mobile, we operate on the premise that actually the mobile phone is already lawfully seized. And from there on, what are the scenarios that could be implemented at national level when it comes to extracting data? But the first, let's say, awareness level that we found to be generally low within the surveyed countries is that there is a very little awareness in terms of the fact that sometimes, even though the information could be accessed through the phone, via the phone, in reality this information is not stored on the device, but it's actually stored on a cloud service. And what we actually also find out about is that although there are criminal rules that are applicable also in these situations, often they don't consider the specifics when it comes to mobile forensics. Often they don't consider the specifics when it comes to accessing information that is in reality outside the physical borders of the jurisdiction. So, and there needs to the departure point needs to build from there. And as another main finding that we actually have from our research is that in reality, mostly mobile forensics are undefined in the respective national laws. And sometimes, although we had a very high-level correspondence, people who are actually working as defense lawyers, even they had some challenges identifying all the applicable rules. So our idea is to bring more light into a field that is still somehow undefined or unguided. So what is the status quo? So what are the main legal instruments that are on the disposal at EU level, especially when it comes to cross-border cases, to judicial authorities in order to request information or to exchange information in terms of accessing information that is in reality in the cloud. So Peter is going to speak a little bit more in terms of how national legislation and national practice interprets this issue, but I'm going to just to shed light on two main instruments. I believe that most of you are already very well familiar with them, but just for comprehensiveness, I'm going to share a little bit more about them. So the first mechanism that exists at EU level, although not specifically designed for electronic evidence, actually could be applied in this scenario as well. So this is the European investigation order that has been established by Directive 2014-41. However, this, according to a very recent study by Eurojust, this is an instrument that is still wildly unused. So there is the potential of the European investigation order is yet to be reached. But just because my intervention revolves around what would be the fundamental rights implications when it comes to the use or the application of such mechanism, I would say that when it comes to the European investigation order, one of the first challenges is the diverse approach that member states applies when it comes to who could actually issue such an European investigation order. Does it have to correspond to the domestic powers or not at all? And actually, this question defines very different interpretations in the national laws, and actually also Eurojust is calling for a harmonized approach in order to have, let's say, an equal level of protection to fundamental rights. And another, let's say, difficult point when it comes to the European investigation order is where to put the delimitation line, because there is very strong mechanisms for police cooperation, and then we have mechanisms for judicial cooperation, but sometimes it is difficult really to draw the line which was which. And this also reflects on the guarantees available to the natural persons concerned. So what has been highlighted in practice as a good solution is that sometimes it might be necessary to conclude additional bilateral agreements really to draw the delimitation line in terms of which, let's say, actions would be classified as police actions and which kind of activities should classify as judicial cooperation. So although we do have this kind of very useful instrument that is applicable and available in the European Union, there are so many situations where in reality the information is stored outside of the jurisdiction of the European Union. So there are other instruments that could be used in order to access and exchange in a very prompt manner information between the competent authorities. And these are usually outlined by either multilateral or bilateral mutual legal assistance treaties. And if the European investigation order was not designed bearing in mind the complexities around revolving around electronic evidence, then the most recognizable mutual legal assistance treaty out there actually deals exactly with that. And this is the Budapest Convention that regulates the issue of seizure and exchange of electronic evidence extracted could be extracted from a service provider. So this is actually one of the most recognizable conventions when it comes to fighting crime and terrorism. It has been ratified by 66 different states. It contains precise precisions when it comes to not only in terms of the exchange of evidence, but also with the mere with the very preservation of the electronic evidence, with the preservation of traffic data. It also implies how to enforce this preservation in other jurisdiction. It contains also rules with regards to search and seizure, but what it currently lacks is the establishment of minimum standards when it comes to the protection of fundamental rights. And this has been this is the responsibility, or let's say the minimum standards are not defined in the convention, but the convention rather leave this to be regulated by the different states who actually have ratified and use the convention in order to exchange information. But you can imagine 66 jurisdictions already there are different rules when it comes to, let's say, the basic procedural rights, when it comes to fundamental rights. And here we're going to talk a lot about privacy, but you know that in the European Union we have one very particular philosophy when it comes to privacy, personal data, but this is not necessarily replicated all over the world. So what is especially interesting in that regard is now that the Budapest Convention is going to have an additional protocol. It is currently in the works. And this second additional protocol actually would contain provisions when it comes to the protection of personal information. And this is a very interesting process that is also being scrutinized and observed and followed by European actors as well. For example, the European Data Protection Board has issued a dedicated statement, and they essentially recommend that this is in fact a document, a convention that goes beyond the territory of Europe. But then again, the Council of Europe has another convention, Convention 108 that has been recently modernized. Thus, it is recommendable that, let's say, the provisions outlining the personal information handling are also in line with what has been guaranteed by Convention 108. And just not to overwhelm too much the conversation, I will now pass the floor to Peter, because I think that I hit my 10-minute mark. So Peter, the floor is yours.
Thank you so much, Denitsa. I think you did more than hit it, actually, but that's perfect because it's, at least I think it's extremely interesting. And I will set the stage for the discussion that we are about to have with the speakers. So will my contribution. So I'll try to keep it rather short, but as a lawyer, being brief is always difficult. So I make no promises, no guarantees, but I will try. So I will try to talk about a little bit more is the criminal procedure report in the member states that we conducted, that Denitsa already elaborated on a little bit. So we looked there quite broadly at how do member states, and then also the UK, Norway, and Kyrgyzstan, how do their criminal procedure law deal with mobile forensics from the phone to the court? So the whole chain, how is that dealt with? What kind of actions are legal? If it is legal or illegal, what are the consequences of those actions? What are the issues? So on and so forth. So just a bit of a disclaimer is that what we will be presenting, what we have as findings is of course dependent on the respondents that we use. So we use national experts in each of these countries. So a bit of a disclaimer that we could always have some understanding that is maybe transposed from a Belgian understanding in my case to an Italian understanding, UK understanding, and so on and so forth. So there's always room to discuss. So if you feel like you have experiences that are useful to share, please do so. If you want to have access to this report, the For Mobile website, which we can put in the chat later, has this report, as well as I have to make a little bit of an effort to put Timelex in the spotlight. The Timelex website also has the general report on the European level, as well as all of the reports on the national level. So if after this discussion you feel, okay, this was quite interesting, and I want to know for my country or for specific countries in which I have a case or that I'm dealing with, what the situation is, we have all of the respondent input in those reports. So that's publicly available. That's freely available. That is in no way something that we want to keep to ourselves. So that as background. So what I'm going to try to talk about, this is kind of the topic that we chose for this webinar, to maybe introduce a broader discussion about acquisition in the cloud, privacy implications. I'm going to tackle it from something that we found quite interesting as the jurisdiction angle, which we found in the national reports. So the situation that we are thinking about is, as Denitsa said, For Mobile deals with the phone in your hand. So basically the police has the phone, typically seized, could also be not seized during questioning. It has the phone in their physical possession. And then the situation we are dealing with is that cloud access is technically possible. By using For Mobile tools, for example, you can maybe obtain the passwords, you can try to circumvent security, or the app is simply open on the phone. Whatever situation you have, you are able to access data that is not stored on the phone and in general memory, but is stored on the cloud. So whatever you are using, it is technically possible. That is an assumption that we are working on. And the question is then, is it legally allowed? And if we look at all the correspondence, the reports, the interviews that we had with them afterwards, it seems that when your data location is known, you can ascertain that the data location is in the own country. So location is known and it is in the own country, then typically it is allowed. I mean, there's certain conditions, there's different provisions, there's case law. Some respondents mentioned, okay, maybe the service provider should agree, but generally everyone said, yes, this can be done. Typically, no real restrictions. The issue, of course, exists when you are dealing with either an unknown data location, which is typically, I mean, not typically, but often the case. You're not quite sure, or you can't ascertain quite 100% where the data is residing, or it is known because you know generally that this information with a certain service provider does not reside in your own country, and you are dealing with a situation where you are trying to acquire cloud data from abroad. Of course, you can always, and this is always a possibility, you can always ask the service provider directly. But whether or not they are obliged to comply with this depends really on national rules, which are quite divergent. So some countries have quite extensive legal obligations, and other countries have very few hard legal obligations to comply. Then, of course, you could also maybe have service providers that are able or that are willing to give you the information. And there as well, countries like Ireland and Luxembourg, where big companies have headquarters, they are typically willing to cooperate quite easily. Whereas in other countries, that is not so much practice, and you will tend to get a negative result. So we're kind of forgetting about the direct cooperation with the service provider, say that is not possible, that doesn't work. There's no sufficient legal obligations to do so. You can always go the route of international cooperation, which again then falls back a little bit on what are the national powers of the requested country. But here we are dealing, as we said, with direct access. So we can directly access, we can technically just take the leap, access the data, use it in the investigation. Great. What's against that? Well, the Budapest Convention that Denitsa mentioned actually says, okay, the rule is that because of sovereignty of states, jurisdiction is based, this international law, on the location of the data on the territory of the member states. So that's the member state that is able to acquire that data. In other words, to acquire data in the cloud when you know it's located abroad is in Article 31 of the Budapest Convention a no-go. Unless that data is publicly available, then there's no issue, or you have the explicit consent of the person who is authorized to have access to that data. If that is not the case, if you are in an investigation, you're technically circumventing, you are trying to use a tool to maybe grab passwords from the RAM memory, you're in a different situation. You don't have the explicit consent. Data on the cloud typically is not publicly available if it's password protected, so on and so forth. So under the Budapest Convention, you are then left with having to go either through direct cooperation, so sending a direct request, or through asking basically through European mechanisms, EIO or the MLATs, to try to get cooperation from authorities in the countries where the data is located. We also talked a little bit, the evidence proposal, the European Preservation Order, European Production Order, this is going to cut time limits, because currently these requests are rather slow and most investigations too slow. This is going to cut time limits, yes. It will clarify the legal framework for service providers. Are they obliged to cooperate, to what extent? So that is all very good. But the issue is that in some investigations, this will still be too slow. If you have possibility of direct access, if you are maybe preventing other crimes, other things from materializing, if you're trying to make sure that evidence does not disappear, there might be still a good reason to access this data directly if you can do so. So we asked all the respondents, okay, how does this work in your jurisdiction? Can it be done, yes or no? The interesting thing is that there are a number of countries who say, yeah, we have read the Budapest Convention, so no, not possible. Unless consent or publicly available. Croatia, for example, Latvia, the Netherlands, Slovenia, and Sweden, a number of correspondents that gave us that answer. Quite interestingly, most of the countries actually said, if the data location is unknown, then we go for it. But also a big number of countries said, even if we know that the data is stored outside of the jurisdiction, we go ahead. Interestingly, not for the same reason. So in Belgium, for example, you have express legal provisions and express case law that says, go ahead, no worries. It's interesting to see how that flies with the Budapest Convention still in existence and Belgium having ratified it. But there's also a number of countries who say, okay, we just do this because there's an absence of rules forbidding it. Because there is no clear legal rule that says we cannot do this. We can, so we go ahead. That was the case, for example, for Cyprus, Finland, Hungary, Luxembourg, and Poland, amongst others. And the last approach is maybe the most interesting one, is where countries are going to say, okay, under basically public international law, we are going to have to employ a legal fiction, and we are going to assume that because the crime is happening in our country or linked to a person in our country, we are assuming that the data is stored in our country, even in the face of evidence that is not the case at all. So they are bypassing that reality and saying, okay, but under public international law, we are linking this back because of the jurisdiction principles. So Greece said that, Italy, Norway, and Estonia amongst a couple. So they kind of take back sovereignty, which is interesting. Generally, however, and this is quite important, even countries that would say, okay, we always use international cooperation, we follow the Budapest Convention, we do not acquire things in the cloud that are abroad, tend to make the distinction, like all other countries, between data that's accessible on the phone, like a WhatsApp app that is open and the phone is not password protected, it's just simply open and it's right there. then they say, we will go ahead and we'll use that as evidence. So even if that would be a Dropbox account or something that is definitely on the cloud and definitely abroad, they might still go ahead and they distinguish that situation from situations where you are technically circumventing or you're trying to get credentials by yourself. So they say if it's open or we legally obtained credentials and we can simply log in, then we can go ahead. Otherwise, not. So it's really on the question of technically forced access using tools to gain access directly. That there's the most disagreement on that. Also interesting, I'm already at 10 minutes, so I will keep it short, but almost there. Is that in a lot of countries, it's not because you were to breach the procedure rules that would necessarily mean the evidence is inadmissible. And so in most countries, the limit seems to be if fair trial is affected, then yes, it will be admissible. Otherwise, issues with formal procedure, issues with privacy seem to be solvable for most of our experts. They say this, you can tend to convince a judge that the evidence is still admissible. So that's an important thing from phone to court. Okay, this is a theory, but at the end of the day, it might still be admitted. And for mobile, we're trying to deal with this. Most importantly, maybe we're trying to also facilitate the location of the data in the tools, trying to say, okay, this is our best information about where the data is located. So you can make your legal reflections on that. We're trying to deal with that also in our standardization activities and training. So this will, even with the new rules, evidence proposal will remain a challenge to balance basically sovereignty and then the fact that information and evidence just does know borders and is everywhere. And that also kind of ties in what we're going to discuss with a number of the speakers with the privacy balance and the expectations that a person has of due process of privacy, but the fact that law enforcement needs to assess what the risk is, need to access data to be able to carry out their jobs and administer justice properly. So that will be a couple of the talking points for later. Something that I definitely want to maybe discuss about is this data location as an aspect to determine jurisdiction. Yes, territoriality is a basic principle in public international law, but when we're dealing with data online, it doesn't seem to fit, right? I mean, first of all, we don't always know the location. Location can change quite easily. You can have relevant data split over different locations that needs to be put together. What are you going to do in that case? What if data is stored in different countries simultaneously? So there are backups, there are copies. It kind of shows that data location is maybe something that we need to think about whether that makes sense at all, to the extent that some countries even ignore it, like Belgium in their express legal provisions. So I would be very interested to also hear what the speakers have to say about all these things. So with my excuses that I made it a little bit longer than I intended, I will now give the floor to Krasimir, who, as we said, is a lawyer at the Directorate of Jurisconsult in the Registry of the European Court of Human Rights. I will give him the floor to express his views, and Mike Dickinson and Martijn will also get their 5 minutes to explain their views, and then we'll get into a nice debate. Also, a warm invitation to the audience to put your questions in the Q&A so that we can immediately incorporate them in the discussion. Thanks, and word to you, Krasimir. Thank you.
Okay, thank you very much, Peter, and thank you to all for the invitation, and thank you to the participants for being present today here. I have to say that the topic itself and also the reading, the report which has so far being prepared was really a fascinating reading to me, and I think opens some critical questions that even if you wish go beyond mobile forensics and open some conceptual debates about the relationship of privacy and effective investigation and prosecution of crime. Taking the perspective from the European Convention on Human Rights and European Court of Human Rights, an interesting point to note is that that the case law on the topic of mobile forensics is rather scarce. This is interestingly also reflected in the report with respect to national case law. So we have an area which is clearly still developing. And for me, it is not surprising that the case law of the court is not so developed, because it normally reflects what is happening on the domestic level. That said, there is some case law, and that said, there is also important to note that there are certain principles which have developed with respect to evidence obtained from other computer systems, which, as also elaborated in the report, is some sort of a generic term which we can always use by some analogy. I simply want to make this point clear before entering further discussion. When we talk about this position of the European Convention on Human Rights in the general European order, then we are talking in a sense, as the court itself said, constitutional instrument of European public order in the field of human rights. And this is basically this European Convention, which is now also incorporated in the EU law and forms part of the general principles of EU law. So this is our legal basis from which I at least look at these things that we discussed today. For the convention, as you can imagine, and I think it is clear that for a legal instrument of a constitutional order, it is difficult to micromanage things. It is difficult to provide in that kind of a document specific details about the tendering of evidence in the proceedings, about different problems and finances and fine issues of mobile forensics. So therefore, I think that the global principles on the fair trial and the protection of privacy are critical to understand here. The crucial importance and the crucial emphasis of the court in this area is the insistence, an absolute insistence on the rule of law. There is a big risk, which the court has on several times recognized and repeated, is that under the cloak of defending democracy and the legal order which we have in Europe, we go a little bit too far. And then from that, applying all these tools that we have in our hands to effectively prosecute crime, we may very easily slip simply into the area of excessive control and oppression and resemble to some of the legal systems to which we don't want to resemble. Therefore, this insistence on the rule of law is in particular important. And I would like to simply point to a certain principles from the court's case law, where the court said that in this area, which touches upon the issues of private life, of respect for home, of respect for correspondence of an individual, law must be sufficiently and particularly precise, clear, and detailed, and that law of such quality must be duly complied. The other interesting point for me to note that at this preliminary stage is that that we also have to start from a perspective that information technologies of any kind, and the court has stressed this in its case law, are content neutral. The question, what we attach to information technologies, that may be something which is illicit or maybe something which is for a normal appropriate use. This is, I think, important to note because we have seen some tendencies that certain information technologies are in themselves taken as being indicative of a certain criminal activity, and that cannot simply be the case. So, so this is a globally picture of a certain of the certain starting point from which I look into these things and from which the convention look into these things, and then I'll be definitely happy to discuss later on some more specific details. I pass on the word to the next speaker. Thank you.
Great, Krasimir. Thank you so much for providing this initial overview that will serve as a starting point for the debate later on. So I'd like now to pass the floor to Martin, who has very much practical experience when it comes to acquiring and assessing, analyzing electronic evidence. So Martin, the floor is yours.
Thank you very much. Yes, I am a public prosecutor and indeed already involved in fighting cybercrime the last 7 years. So a normal working day involves the violation of privacy rights of certain individuals, as well as cooperating with other countries on the basis of EIOs or the Budapest Convention and the preservation of data to secure evidence internationally. And especially the topics Pieter already mentioned, like what does the loss of location mean in practice for people that are in a house doing a house search while the investigative judge is present? What are they allowed to do? Can they extract the evidence of Dropbox? What are the rules in the Netherlands? And what is our perspective on sovereignty if the location isn't clear? At this moment, I'm not representing the Public Prosecutor's Office, but I can tell you that the view of the Public Prosecutor's Office in the Netherlands at the moment is that if the data isn't located somewhere, so if you have a loss of location situation in which, for instance, the information is divided over multiple servers like Dropbox or iCloud or Google Drive is doing, we tend to advise the investigative judge and also our police to extract the evidence in a search when we are allowed to extend the search we are doing on the device to another automated device. So in the Netherlands, we are allowed, if we have a house search or a search in a company, to do a search on the device and to extract evidence on that device, but we also have the authority to extend that search to other devices that are normally connected to such a device, and the person that uses that device is also authorized to use. So that means that if we have a search, we, in the perspective of the Public Prosecutor's Office, also are allowed to extract evidence from other devices. The problem is that in the Netherlands and in most European countries, the laws were drafted in a situation where we didn't have external storage. So what we see now is that technology is going so fast that almost every individual is keeping their photos, their personal belongings somewhere else. They all have free external storage. But that external storage contains, in a lot of criminal cases, important evidence. And in a lot of cybercrime cases, it's only external storage where the information is stored by the cybercriminal. And that's mainly information from victims. So our information, when we are victimized, is stored somewhere else by the cybercriminal. The difficult aspect now is the law still foreseeable for individuals? And when I say individuals, I also mean for perpetrators. Is the law still foreseeable that prosecutors and police are also allowed to extend the measures they always had, like wiretapping or securing evidence at companies? Is that also foreseeable for people that we indeed extract evidence out of the cloud? Because it's still the same standards we have to use. You have a certain type of offenses in which we are allowed to secure evidence and do a house search. So that's still foreseeable for a suspect. But is it also foreseeable for that suspect that because he stored his evidence somewhere else, that we get the evidence from the external storage? We say, as a Public Prosecutor's Office, yes, that's foreseeable. There's still the same standards to extract the evidence, but we'll see. At the moment, our jurisprudence is pointing in the same way. The other important and difficult topic is indeed sovereignty. What are you going to do? Because, for instance, yes, Microsoft has an office in Ireland. So if we have a Dutch suspect that has a Hotmail account, we have to go to the United States, Microsoft United States, who tells us to go to Ireland, and then someone in Ireland is extracting the evidence from a server located somewhere in the Netherlands, because we have a big data center in the Netherlands. So sovereignty is strange, because in that case, the Irish police would breach the sovereignty of the Netherlands, extracting the evidence from a Dutch server for the Netherlands. It's becoming more and more complicated. In the Netherlands, we have a certain rule, and we say problems of sovereignty aren't something a suspect can rely on or can use to say that evidence is inadmissible, because sovereignty isn't there to protect a suspect from violating its rights. It's there to make certain that certain states between each other respects each other's laws. So that sometimes makes it maybe easy to say we don't care about sovereignty of another state, because we know it won't have any result in court. That isn't the way we treat sovereignty. We try to respect the sovereignty of every country in every aspect. But if we don't know where the location of the data is, we probably will extract evidence if we are allowed. That's all for me at the moment.
Perfect. Thank you so much, Martijn, for that insight. Very, very insightful, very interesting. Now, Mike, I will invite you to give your view.
Thank you, Peter. Let me say, first of all, I'm the least qualified to give any legal opinion based on the 5 experts around me here. So I'm Mike Dickinson. I'm a former law enforcement officer from the UK, but I'm also now the Chief Business Development Officer for a company called Microsystemation, MSAB. And we are one of the big providers of technology for mobile forensics. And so I come here representing that side of the equation to give you a balance and a perspective. And I think we have many pieces of information that we can give you, but it's not our place as the tool provider to define what exactly how the law can be interpreted around it. That said, we do listen very much to the users and what they want. And ironically, we're being pushed in the other direction, which is our users are asking us constantly to extend the capability and scope of what we can do with technology, whilst everybody else is trying to look about what's the balance between data privacy and the right to a fair trial. Things are changing so rapidly in the technology business, it's very hard to see how the law can keep up with this, because just today I've acquired a new smartwatch, and we know that smartwatches can do things like measure heartbeat and monitor pulse. This one can measure my blood pressure. That's new. Okay, so this is a new data artifact that somebody somewhere is going to have to ask us to acquire and interpret. I would like to say that this in my opening piece, and I will keep it relatively short because I know we're over time already. The technology that we provide and the way that it's used isn't just for criminal prosecution investigations, although that's clearly the core topic here. The technology can be used just as much to help victims or witnesses, and I think Chris said it very well earlier on. It's content neutral. The technology provides scientific truth about what the data is. That data often proves people innocent. It's also used by law enforcement agencies in non-criminal matters to find and help locate missing persons, people with concerns for welfare. So this technology has a very broad scope, and it isn't just on simple black and white of, well, is this good, is it bad, should we use it, shouldn't we use it? And even when the answers and the questions come related to, well, how can you use this technology and what can you get from it? Sadly, often the answer is always, it depends. This is an incredibly complex area. It's a very advanced scientific method. We have theories, and we can gather data, and then things change very rapidly with technology. And I'm sure you've all seen it with apps and solutions and smartphones, how rapidly that pace is moving. The other point to mention is that our technology comes with protections built in already, thanks to the European Union. It's slightly out of scope for this topic, but because of what we do and how powerful the technology is, it can breach decryption and break security. It is already classified as a dual-use product and has export controls. So outside of the European Union, microsystemation has very careful controls and government oversight on who we supply and who is allowed the technology to ensure that we're compliant with democratic support and we respect human rights. And those regimes and states where the technology is at risk of being abused, we simply won't supply. So that's my opening piece. Thank you.
Mike, thank you so much for providing also the industry point of view, because this is something not to be ignored. And actually, this is a very, very important part of the equation, as you said previously. So in order just to spark the discussion and open the debate between you, I just want to reflect on a little bit on in terms of what Krasimir shared and in terms of his intervention. So you mentioned that actually the debate opens a bigger question in terms of how privacy could potentially affect the whole process of investigation and prosecution. But could you please detail a little bit more in terms of what would be the key requirements posed by the European Court of Human Rights when it comes to the search and seizure of electronic data carriers?
Yes, indeed. The first general rule here is, and it's clearly stated in the case law, it's not the question of my interpretation now, which of course I think it goes without saying, and as Andreas said initially, this is all my personal views. I'm not saying that the court will definitely not saying that the court will rule it this way if a case comes before it. The first critical rule is that any seizure of mobile phone must be based on an order in which it is explicitly included in the list of items that can be seized. So a mobile phone as such is an object which cannot be seized without an explicitly set order for that purpose. Then the very seizure of a mobile phone as a data carrier, and then also all the process of seizure and search must be properly documented and detailed. So there must be a possibility to follow on the chain of custody with that respective data. The critical problem here is, as we already discussed, is the protection of that part of the data which is not necessarily needed for investigation purposes, which should form part of certain private or protected data on that mobile phone. Interestingly, in a case which is not necessarily related to criminal investigations, the court, and this is a case for those who want to follow, is Libert versus France. It concerned internal investigation within the French railway company of the computer system of an individual who was suspected of holding pornographic material on his work computer, where the question arose that whether he sufficiently identified part of the data on his computer system which was private. If he properly identified the data that was private, there would be additional safeguards and protection to the data and could be excluded from the scope of the search with relation to possible infringements of work regulations. However, this particular individual did not properly identify his data as private, and therefore the fact that the data was searched was not problematic. As an example, rather than providing big theories behind it, I would also mention a case which is called Saber versus Norway, or Saber versus Norway. I know it's a case from 2020, which is a relatively new case and concerns mobile forensics. In fact, it was a mobile phone which was seized from a victim of crime. But what happened in Norway at the time was that all the data on the mobile phone which were found, there was a mirror copy image that was made and was submitted to the relevant court. The rules on the basis of which this was done was, as Martin already mentioned, were rules on the general procedure also applicable in Norway with respect to confiscation, seizure of data, and then their processing. The problem that happened was that it was expected that the judge and the court would sift and filter data to identify those that are related to the investigation from those that may be specially protected. For the European Court, this wasn't sufficient. The court considered that this procedure, which was based on general rules without specific and clear regulations how to approach data contained on a mobile phone in order to avoid that the data which is protected to be compromised, this was in breach of the right to respect for private life and right to privacy under Article 8. I have to make an additional explanation here is that the risk of data being compromised in this case was in particular important because it concerned data of communication between the victim and a lawyer. So this is even a specially protected form of data. So these would be, so if you would want to extract some general rules from this that I now said, there should be an order which should clearly identify the obligation to seize or the right to seize data. Everything must be properly documented and processed in that way. And there should be specific and concrete regulations which are sufficiently effective to avoid any data which is of private nature from being compromised. On the other hand, the individual may be requested to clearly identify the data which would then have to be protected in this context. So that would be in short, short overview.
Thank you very much, Casimir, for that. I have a question for Martijn. You talked about the application of basically all the rules on search and seizure, which is the case in every European country. They're applying rules that are not really meant for mobile forensics, that are more, they were thought of in the idea of physical evidence, maybe a diary, maybe some documents. All of a sudden, you're dealing with a mobile phone that contains basically your whole personal private life. At least that's the extent of access, and then technical tools often will allow all the data to be extracted. So it's up to the prosecution to deal with, okay, how are we going to access the relevant data? How do we make sure not to access too much? And that also then ties in a little bit, I think, with the whole question about are certain actions foreseeable? Is extending the information on the phone also to the cloud, is that foreseeable? It starts, I think, with, is it foreseeable to use all of that information that is on the phone, just on the memory of the phone, but then also to extend it further to the cloud. How do you deal with finding, in practice, with finding the privacy balance there? Because of course you need the information, you need the evidence. You also need evidence that will show that the person is not guilty, right? And so a number of UK cases where people were convicted of rape, but at the end it was found that certain information was not looked at that actually exonerated them. So I wanted to ask you, how does your office, how do you approach this kind of challenge on a daily basis? Are there guidelines or how do you go about it?
That's a good question and also a difficult one. Because we have more and more data every day, we produce more data, so we store more data as an individual. It's exactly what you see when you start the investigation, or when you start analyzing the data and securing the data, you don't necessarily know what you're looking for. And that means that usually police wants everything. And that shouldn't be the case, because if you have an external search and you know what the offense is, you can also limit what you are looking for. So within a certain time frame or a certain type of data, only GPS data or only photographs and not something else. So you can limit it on that way. Another problem by doing it like that is, and I think Mike has more to say on that, if you want to do it in a forensic way, you have to be able to reproduce it. And to reproduce the evidence that was on the phone, the best way is to make a mirror of the whole phone, because then you can investigate the mirror on the phone and not the phone itself. And so you won't jeopardize the evidence on the original phone itself. By doing that, you are securing more information than you necessarily have to. And is that something we can balance or not? Our Supreme Court recently said, if you have obtained a mobile phone, historically speaking, we could do everything on that phone. 2 years ago, our Supreme Court said the violation of privacy you can make by just analyzing the evidence on the phone itself is so big that when you secure all the evidence, you need a higher authority to authorize analyzing all the data, and you have to have a plan how you analyze it. So in practice, what is my advice to colleagues? First, if you obtain a phone, put it on flight mode, because then at least you know you won't get evidence that is stored somewhere else. Secondly, you have to decide if you will analyze the phone by just looking at it and scrolling through some WhatsApps, or you need to analyze everything. If you have to analyze everything, make a forensic copy, and then make a work plan what the evidence is you're looking for. And how do you say that? Not securing, but getting rid of the evidence you don't need. We need more guidance on that. I can be clear on that. We're not that good in throwing away materials that we don't need or don't use. And we could do better on those topics.
Yes, but of course, always a risk as well that you may need the material later on. I mean, I think that's the big tension that remains. Also, if you see for the Information Commissioner's Office in the UK, for example, they, from a data protection point of view, they said, okay, you have to make sure that there's certain granularity in what you gather, what you process, to make it not excessive, a data minimization principle for law enforcement. But in practice, I feel like from the experience that we had, it's incredibly difficult to determine that at the outset. I think that, and maybe if I may bounce a question to Mike, because it might be quite interesting. Maybe you can also say from a tool provider point of view how you're trying to deal with this granularity question and this selection process, because there's a number of features I know that you've implemented to deal with that.
Yeah, thank you, Peter. Yeah, Martin made some really great points there. This is really quite the challenge, both technically, operationally, and also legally. We've worked hand in hand with the Information Commissioner's Office from the UK, because they seem to be very advanced. As I think it was the first report we've seen into data privacy and mobile forensics specifically, and they did an excellent job in sort of highlighting some of the areas of concern. But they also grasped this difficult balance so that, you know, if you have the right to a fair trial, you can't know at the beginning of the investigation what might be relevant to a case at the end of the trial. So the very act of deleting data runs with it great risks that you end up removing data that could have proved the client innocent. So I think from a good practice perspective, we're on the side of getting the data, but then what we call in our technology, we create a subset of that. And we only forward the relevant data to the investigators for analysis and decoding, or we only pass that to third parties for review. And they're able to be introduced stage sections of review where we decide what case data is relevant, what is private, what is sensitive, and what needs to be locked away. Sometimes there are technological barriers to this, so we physically cannot be selective about the data that we want to get off the device. There are other occasions and other ways where we can get into the technology that will allow that and facilitate it. So sometimes law enforcement are forced to require all the data from their mobile device, because the only way to do it is a methodology called physical extraction, and that means dumping the entire memory, and you don't know in advance what's on there. You have to decode it in order to make sense of it. So there's no way of predetermining. However, there are other methods very commonly used. There's a technique called a logical extraction, where you interact with the operating system on the device and actually ask it for specific things. Now, in those circumstances, you can implement really effective technology to help with data privacy. And we've done that in our product XRY with the help of 4Mobile over the last couple of years of this project. So you can, for some devices, in some situations, enable it so that it operates. Perhaps you're dealing with a victim or a witness who've just witnessed a major incident. They've got photographic evidence of a terrorist explosion going on in the high street, but they're there with their personal phone and the whole life's on it. The last thing they want to do is hand it to the police and see that phone disappear for the next 3 months, because how are they going to do banking? How are they going to do anything with their life if they lose their phone? So we have the ability to deploy technology at street level with consent and basically connect a device to their phone, show them the file that they wish to hand over, and capture an electronic signature of approval, and just take that data. And they can see that we're only taking that specific video or that specific picture. In other situations where we have a suspect device, we can still restrict it. And if the case is specifically relevant to, say, I don't know, some harassment via WhatsApp on chat messaging, we can actually say, okay, we're only going to recover extracted data from this particular app. We can discard the rest because that's what's relevant. And perhaps there are legal search warrant criteria wrapped around it that say, well, this event happened in the last week, so anything that's beyond a week's old is irrelevant. So we can apply a time criteria to that as well and say, okay, we only want WhatsApp data and we only want it for the last week. Now, there is always a technological risk that we're going to miss something through that process, but we can deliver a subset of data that effectively just gives things relevant to the case at that time while storing the remainder of it in the background. So there are ways to develop the technology to help with data privacy, and we've enabled a lot of them, and keep the data secure and retain a master copy. It's not perfect, but we are developing the technology rapidly to help.
Great, Mike. Thanks so much for providing this practical point of view when it comes to these huge, I would say it's chicken or the egg, or whether we have to preserve the privacy of whoever is concerned, who is the owner of the phone, and then on the other hand, we always have the interest of justice, and we always have the public interest of solving the crime, and this is a very tricky balance to strike, and this is something that our work very much revolves around in the 4Mobile project. But having this in mind, and speaking of safeguards, and speaking of means in order to guarantee that fundamental rights are indeed respected, I'd like to ask Krasimir, so what would be, let's say, the guarantees to protecting the right to fair trial when it comes not only to collecting, but also analyzing and admitting electronic evidence in criminal procedure?
Indeed, but just before I start, there was something very interesting which you said earlier, and I think I would use a parabola which was used by a philosopher of criminal procedure, Miriam Damashka, who used Freud's system of id, ego, and superego to explain how criminal justice should work today. And then he said, criminal prosecution is the id element. It's something which has this instinct to prosecute, something that has this urge to go and dig and find and investigate and prosecute. Human rights come here as a sort of certain superego, certain morality to the whole thing, and want to establish a certain balance. If one of the two elements overweights, then you have unstable system. You have a mind which is not properly operating. So I do think that the whole human rights element should be there to put this certain, let's call it morality, to the whole equation, but definitely should not be there to suppress effective investigation and prosecution of crime. When it comes to the admissibility of evidence, it was very important, I think, that your report disclosed that there are different systems in Europe on admissibility of evidence. And we can have serious disagreements over which system is better and which one is not. Some systems take it very critically and exclude any evidence that can be unlawfully obtained. Other systems are more flexible in that sense. Therefore, from the perspective of the European Convention, which is a legal instrument that covers 47 different systems, it was impossible to devise one single rule that would work for all relevant legal systems and countries. Therefore, there is a certain test on the admissibility of evidence, which is in the court's case law called BCOP test, which was devised in the context of secret surveillance. That relates basically to the questions of the existence of any doubts on reliability and accuracy of evidence, on the possibility of the person concerned to raise those doubts as to the reliability and accuracy of evidence in the court, on the obligation and the possibility of the court to effectively investigate all those concerns and provide reasons why accepting some of them or not, and finally taking very importantly into account the weight of evidence. The more important evidence, the more important safeguards that the authorities need to invest in making sure that there are no doubts as to the reliability and accuracy, and that all doubts have properly been addressed. Very important is also chain of custody, which we previously mentioned. The court was very skeptical in accepting the admission into evidence of a material where the originals were missing. So we did have some cases where simply it was impossible for the defense finally to trace the original recording or other data, but had to rely on its analysis by a certain expert which was provided in the file. This wasn't well received by the court. It is also important that the court stress that the court has accepted in the case that there is a possibility to protect secrecy of investigative measures and methods. However, that has to be, the test is very strict. The court said it has to be strictly necessary. It has to be counterbalanced by some other procedural means, which may be some extra parte examination of evidence or methods by the judge without the parties, or the participation of lawyers with special clearance certificates and things like this. Thing that I would also like to mention, which has arisen in recent times, is the processing of a huge amount of electronic data. Normally, it would be difficult to simply dump on the defense a huge file which would consist of millions and millions of pieces of data, of emails, of other exchanges, and so on. And there should be a possibility to include the defense in a cooperation with the prosecution to devise the method how to filter this data and how to extract those that are relevant. And also to allow the defense, once certain data is tagged, is identified as relevant, to further be able to sift through it. One of the critical points that I simply briefly want to mention, and it was emphasized in the report, is the problem of privilege against self-incrimination and the famous Saunders formula. There is this case which is called Saunders versus UK, where the European Court famously, in passing, in a case completely unrelated to the topic, but in passing, said that privilege against self-incrimination would not apply to evidence which is will independent of the person concerned. The problem with this will independent is that across Europe, and you have shown this in your report, is being interpreted in all sorts of possible ways. But I think for the very simple reason that we can probably have 3 seminars and not agree finally on what is a will. What do we mean by will, and what is then finally will dependent and will independent? So I would want everybody to calm down a little bit about Saunders' formula. It has still not been clarified in the court's case law what is will dependent, what is will independent material. I know that in the Netherlands, and Martin will probably confirm this, they have serious litigation about this, and I think there were even disagreements between the Advocate General and the Supreme Court on how they see will dependent, will independent material, and so on. But this whole Saunders formula and will independent material has to be taken with a certain caution. Interestingly, very recently, Supreme Court of the Netherlands has adopted this judgment that forcing an individual to provide biometric data to open a smartphone did not breach privilege against self-incrimination on the basis of all these complex rules, I'm almost sure that the case will end up in the European Court. So I don't know, like, who knows? But this is not only typical for Europe. In the US, you have serious discrepancies in the case law and in the proceedings in interpreting how privilege against self-incrimination works in this context. In the Indiana Supreme Court, very recently, you had a ruling according to which obliging a woman to provide passcode to enter her smartphone was in breach of privilege against self-incrimination, and almost more or less at the same time, you had Supreme Court of New Jersey, which ruled that it wasn't contrary to privilege against self-incrimination to oblige an individual to provide passcode to a mobile phone. So we see that this is still a globally developing topic. So thank you.
Krasimir, actually, this is one of the questions that we very much examined during the course of the project and during the course of our study. And thank you for raising it. And since we have only 15 minutes until the end of the webinar, I would like now to open the floor to asking questions that come from our audience, come from the participants here. So the first one actually is addressed to Martin, taking into account that he was involved in the EncroChat case. So to piggyback of what we had just discussed, to piggyback of Krasimir's intervention with regards to safeguard, what are, let's say, the main lessons that you've learned on the basis of this case when it comes to protecting privacy and fundamental rights?
That's an interesting question, but I cannot say anything about it. There is within Europe, and it's not only in the Netherlands, but it's also in France, in the UK, in Sweden, in Norway, Poland, and I think a lot of other countries, evidence obtained or gathered or given to other countries that was obtained by France using an interception tool. That evidence was spread by France to other countries, including the Netherlands, that was part of a JIT. And indeed, in a lot of those cases, the chats of the individuals were related to criminal offenses. And a lot of cases in the Netherlands have an ongoing discussion on did France use all the necessary, did France have the necessary, how do you say that, laws to use this interception tool? I cannot comment on that. That's something, at least the Netherlands says, is first to answer by France. France was the country that used the interception tool, that had the allowance of an investigative judge, and they used their own law to do that. Then it's also up to France to see if they followed all the rules in the right way. I don't think we as a Dutch prosecutor or even as a Dutch judge are able to interpret the French law and to say, well, the French did a good or lousy job. So at this moment in the Dutch cases, we say, looking at the international principle of trust, it isn't up to the Dutch court to interpret or to rule about the French use of the French law.
All right, thank you for that. Another question from the public is, and I think it's for you as well, Martijn, sorry, does the Law Enforcement Directive Article 25 logging obligation to log all kind of processing activities, does that apply to data extraction from the cloud in third countries? So do you record, according to the LED, the transfer of such data back to you? I would say, I would think yes.
I would say I don't really understand the question, so that's a difficult one for me. Do we our investigators are obliged to make a transcription of what they are doing. So if they get evidence from a device or from the cloud, they have to make just a transcript of what they are doing. They hash the data they obtained to make it in a further stage able for some other expert to see that the data hasn't lost its integrity. So that's, I think, for now, the only thing I can say.
I could add a little bit to help, and just from a technical perspective, the tools we build are built to that specification to log and audit every activity that takes place. So there's an independent audit trail that a third party working on the defense can follow the same procedures and get the results. And that applies for either the mobile device or a cloud extraction. And just to practically explain, what commonly happens when you extract the data from a mobile phone is often you recover tokens for apps that would allow you access to the cloud. The choice legally whether you can use that technology, whether you should, is entirely with the law enforcement agency that possesses it. And it's not necessarily automatic that cloud data comes. They have to make a conscious decision to take it.
Great, Mike. And to profit from the opportunity that you have in the mic on, because you have a really large experience also being provider of a technology across the world, let's say, do you know, or do you have this experience where cloud providers themselves sometimes hinder the process of acquiring the data, even though there is, let's say, a court order issued, dedicated court order issued, or you have experience where the cloud providers are always cooperating?
I can only give you secondhand information from our customers who've experienced it, so I'm not first-hand party. But I think the answer is it depends, and certainly the local jurisdiction of the cloud provider is very influential on whether they cooperate or not. And we do see that US law enforcement seem to get much more greater access to data if they serve a search warrant on a local US orientated organization like Apple or Google than our colleagues across the border in Europe. But that's not to say that it doesn't happen. And I think you have to work in context. The technology is changing and developing exponentially fast. It's almost impossible for the law to keep up with this. And I think that's the challenge. But we are clearly seeing patterns from your European law enforcement colleagues that they are able to serve search warrant notices via the appropriate legal channels through government approvals to these providers and recover the data. It may take a long time. Some will resist. Some will say they don't retain the logs. But yes, there is cooperation going on where they feel there's legal powers. But again, that is different for every region across Europe.
All right, I have another question from the chat, which is an interesting one. It also is proceeded by saying playing devil's advocate, so that already introduces quite nicely the question. If you are going to restrict, and this is basically the essence of the privacy balance again, if you are going to restrict the coverage of the investigation, the scope, if you're going to not look at certain things, does that not provide then possible safe spaces based on format, based on type of information, based on apps, whatever, to hide information so it's not exploited, detected, and so forth? I think the answer is yes, that could happen. Mike, maybe you can elaborate.
Yeah, that's the simple answer. Part of that process is how do you deal with transparency versus disclosing operational police procedures to the point where you actually end up educating criminals. And again, it depends. There's a balance. We want transparency and fairness in our legal proceedings. We want the right to a fair trial. We're willing to give information about how technology works, but I'd also be completely against broadcasting our capabilities on a general level to educate people what tools we can do. I mean, it even boils down to the list of devices that we can support. There are some phones that we find it much harder to get the data out of than others. That broadcasting that knowledge publicly would just help criminals, nobody else. So we keep it confidential. But that's the challenge at all times. It doesn't mean we wouldn't disclose it for a court of law for a fair trial, but equally it would be foolish to give people an advantage by identifying where the weaknesses are in the technology, or where certain organizations across Europe have limited capability compared to others. This does not help justice. So I think we all have to apply a degree of common sense and balance and find that fairness there.
Yeah, and I think it's a very good point. I think that's also generally something that we saw in the criminal procedure report, is that in most countries currently, both in terms of getting access to the evidentiary data, so getting a copy or being able to check that, as well as getting information about how the tools work and, you know, what kind of mechanisms there could be, you know, lead to certain information that maybe you want to question this or that. Okay, we talk about chain of custody, that is often there, but all this information doesn't always reach, or in most cases actually seems to not reach the defense. I think that's also a quite interesting balancing exercise that you'll have to do, that not in terms of privacy, but in terms of how much can you disclose, how much should you disclose for a fair trial, a fair defense, without you know, going too far, and then at some point leading to the technology being exposed in terms of, well, weaknesses, potential issues, to the point that even if it's I think if you take the signal example, if it's sufficient to confuse enough people, and if it's sufficient to confuse the judge that it's not reliable, you might end up, from nowadays, it feels like sometimes the evidence is treated too much as objective and definitely true and no issues, but you don't want to end up at the other side where this very useful evidence is treated as, oh yeah, but you know, tons of things could be wrong with it, so let's not rely on it at all.
Yeah, absolutely. And I would say, and Chris may raised it about the data overwhelm, the issue of data overload is endemic to all parties here, both prosecutors and defense. The law enforcement agencies we deal with can't cope with the volume of data that we can present in our technology. There's, you know, I think we referred to a rape trial where the suspect was found innocent because they're actually buried amongst 300,000 WhatsApp messages were proof of consent, but just that the officer didn't have time to locate it. And so this is a real problem. And we're trying to develop the technology to allow filtering so you can ask the right investigator questions, who, what, why, when, and apply filters on it. But fundamentally, as a safeguard, best practice is to recover all the data and then store that as a master copy. Don't have to analyze it, look at the data, so you have it as if there's a subsequent challenge or a defense argument that warrants going back to it. Because if you don't hold on to the mobile device and you return it, that is the original evidence, you run a risk.
Yes, and speaking of having all the necessary information at hand, even if you don't have to immediately analyze it, we have maybe one final question to Martin again. And this question actually considers social media and our conversations and our communications that happen in social media. So let's imagine a situation where you actually have seized a phone and you would like also to use the information from social media. So how far you can go into scrutinizing contacts, and especially how far can you go in view of the messaging that has happened on that particular social media?
Also, in this case, like Mike said, it depends. For us, we have, if we obtained the phone, our law says if you don't have a search, you're only allowed to look at the data on the phone itself. You aren't allowed to do an extended search. There is a law coming that will make that possible, but I only expect that in 2022. In those cases, then after we obtained only the mobile device, we are also allowed to do a search on the extended storage. How far can we look on social media, that depends on which information is on the phone itself. So if there is a lot of chat communication, or all the Instagram photographs are on the device itself, or the Facebook app is storing information on the device itself, depending on the investigation and the suspicion we have, we are allowed to look at the evidence on those social media apps. If you're having a case in which, for instance, a naked picture of a certain person is being transmitted in a WhatsApp group, you're only allowed to look at data related to that picture. And you aren't allowed to see if he is also in a Telegram group dealing in drugs. That isn't something you should do. That isn't in our rule of law, but it's only proportional. So the rule of proportionality will give you a leading in that.
All right, thank you, Martin. I think we have reached our time limit, Andrea. So I will give the word back to you with a big thank you to all of our speakers for your insights today. Maybe there's also a way to get the recording and the practical details for people if they still have questions. We'll leave that to you, Andrea.
Absolutely. Thank you very much, Peter. Thank you, Denitsa. Thank you very much, you all, Martin, Krasimir, and Mike, for all different views that you have shared with us today. It's been an intense 1 hour and a half conversation. I think I've learned so much. So even thank you as a criminal lawyer by background. Actually, I found it really fascinating and eye-opening. I must say that I sympathize with all of you because you cover different roles in this complex scenario where technology evolves every single second, as Mike says, really. So you all repeated again and again that the scope here was to strike a balance. I believe that from Privacy Rules perspective, actually the balance that we want to strike is to offer the possibility to all of you to interact on our platforms. And I'm very pleased that there were so many questions because these evidently attracted interest from the public we had out there. So I can confirm that the recording will be published on our platforms, as the list of the jurisprudence that Krasimir in particular shared with us today. I posted them in the chat, but actually these will be replicated. We will also prepare a report that will be first agreed with the speakers and then disseminated to the wider public so that the main concept expressed by all of you will be available there and used for future digestion, so to say. I anticipate that maybe we will invite you all again for seeing, the state of play sometime ahead when the For Mobile project will have evolved up to the final stage. So in these regards, actually, Privacy Rules welcomes and thanks warmly also the For Mobile project for accepting to speak about its work through Denitsa in particular here with us today. So I just want to conclude by really thanking you all 5 panelists, I would say, not only the 3 of you, but the co-moderators, for sharing your experience, your thoughts, your ideas, and your vision with us. And so hopefully you will stay and remain safe, not only from cyber criminals, but also from the pandemic. So thank you very much, you all.